Hello, everybody, and welcome to the another session of In Leader's Mind. My name is Thomas Tomasevic, and today I have an honor to talk to Brad Barth, who is one of the attorneys from the Barth Calderon Attorney's Office, located in Osage County in California. Yep. So I had the pleasure of meeting one of the, I guess, founding fathers of Barth Calderon, Barth Harry. In other words, Harry, I believe he is related to Brad. Mm-hmm. And I had an honor to hear the long version of the asset protection panel that he gave to my Vistage groups. And we enjoyed it, and some of my members reached out, and they are working with the Barth Calderon attorneys, but I wanted to have a short version for public showing so that we can share that with the rest of you guys.
Great.
The attorneys that I'm talking to are experts in the field that I'm interviewing Brad for. They are asset protection, estate planning, property transfer, tax laws, business succession, charitable planning, and all sorts of different probably trusts and LLC that come along with it. And essentially, their objective is to help us in this changing climate to protect our wealth, make sure that we have some amount of generational confidence that we will leave things behind, and protect our assets in the process of running the business.
Right.
So, Brad, would you like to say a few things about yourself?
Yeah, sure. Thank you, Thomas. First, I thank you for having me as your guest speaker, and it's a pleasure meeting you. And thank you, everyone, for taking the time to listen to this presentation. Yeah, Tom, thank you very much. I have been working with my father, Harry, for the last 24 years, and we do have a carve-out specialty in our area of asset protection, both domestic, international, simple to advanced. And that also kind of pours over into the estate planning area. Most of our clients are business owners, so you really can't separate their assets, their businesses, and ultimately their estate plan and business succession plan. They all kind of fit together. So we kind of service that marketplace. So although this may be a talk specifically geared towards asset protection planning, I'm certainly going to cross over into estate planning land, because like you mentioned, some of the tools that we use like trusts really do have a multi-generational scope to it. So I've been with my dad now for 24 years. I myself am a Vistage speaker, thankfully, for probably the last 15 or so years. I do have a chance to go around the country and meet many business owners. And as you mentioned, it actually is a very well-received presentation. Sometimes, believe it or not, 3 hours simply isn't enough to kind of deliver the message. So any type of supplement that you can offer your members like this is certainly great. So besides just the asset protection planning and estate planning, you mentioned also we do real property transactions, contract matters. I work a lot with charities, a lot of philanthropic type of work, and and pretty much anything that a business owner needs. Just for a little bit of background on the firm, we do have 34 personnel. So we are a nice mid-sized law firm. I think 12 to 15 of which are attorneys practicing in various areas to kind of service that market. So although my father and I may be the face of the firm, we certainly do have an excellent team and support staff to help facilitate whatever it is that we're working with our clients on. So thank you.
Love it. Thank you very much for that. And obviously, a level of expertise is needed for this topic because it is a changing target and it's a very relevant one. So why don't we start with the simple question for our audience? What is asset protection? What is included? What does it apply to?
Great. It's always excellent to start off with a foundational definition. What are we talking about here? Absolutely. Yes. And I've found that over the years that even my own definition of asset protection planning has changed. And when most people think of asset protection, they think of like hiding their assets or making their assets unobtainable by creditors. And there are some tools in that regard. But when I like to define asset protection planning as basically a form of financial self-defense. In other words, there are within the legal system, there are tools that opponents and plaintiffs' lawyers have to attack our clients, attack their assets. And what we do is we use those same type of tools to build fortresses, to build walls, to help mitigate some of those risks. So just like anything else, it's really a matter of a punch, counterpunch. And ultimately what we decide to do is design a structure that doesn't make you impenetrable. you're not about hiding the assets. That's the last thing that you want to do. But you want to have a structure in place where they ultimately say, you know something, I may win litigation. I may win the litigation. The challenge is, Tom, they can't collect, or the ability to collect on those assets is so expensive, timely, cost prohibitive, that we're just better off in entering into a settlement agreement. Because could they pursue the assets? Yes, they could. But what will it cost them, and what will they actually net gain at the end of that transaction? Less time, expense, headache. So the way that I define asset protection, it's creating the appropriate number of barriers to change the litigation playing field, to give our clients the maximum leverage. And that's the key word, the maximum leverage, to be able to negotiate a fast and favorable settlement with the creditors. Dom, there's nothing that we can do other than to advise you to act as a reasonably prudent person in both your business life and personal life. But if you're going to get sued, you're going to get sued, right? You can be sued for any reason by anybody at any time, right? It's just the lawsuit lottery. The question here now is, how do we get you out of that as quickly and as favorably as possible? To me, that's what effective asset protection is, as a good definition.
Love it, love it. And this is a litigation happy society. In other words, we have everybody suing everybody, or essentially the question is here, if that part, that the litigation part of the economy or the industry has grown, has the protection grown as well, and you are part of the protection. So for those of you who are not favorable with attorneys, this is a good one, because he's talking not about litigating, but about protecting you.
We're on the good side of the V.
Exactly.
Exactly. Two sides of the V. We're on the good side of the V, not the bad side of the V.
Absolutely, absolutely. So in other words, one of the things that we're talking about is protecting against litigation. Another one, I assume, is protection against different taxes that happen along the way.
Yep.
Watering down the wealth of the family, individuals, etc. Probably some of these things are heavily impacted by the tax laws that we are seeing as well.
Yep,
and
absolutely. Yeah, absolutely. Let me go ahead and address that, because there's a couple tools that we have, and this presentation, at least this answer, is timely. As you know, and I'm sure most of your audience is aware, that there's been a constant moving target in Congress as to what's happening with tax laws. We're from one administration to the next administration, and who knows what's going to be the next administration. So we as attorneys in the area of more on estate tax minimization, we always have kind of this moving target. And so some things are very important and timely, and some things aren't so important and timely, absent Congress making some changes, which they're planning on. So the nice thing about it is that not only do we get to double dip, not only do these tools allow us to minimize our state taxes from a legacy point of view, but we also use a lot of these same tools in the asset protection area. I think, as we may have mentioned already, there's a lot of crossover between asset protection and estate planning. And when you start getting into estate minimization tools, because, Tom, in order to really worry about estate minimization, you typically have to have an estate. And where we're holding today, that is in 2022, at least the current estate exemption is about $12.06 million per person. Now that's huge. And if you're married, that's $24 million that you can pass to the next generation without incurring any estate tax. Now, there could be some members in your audience that have a state death tax. I'm referring to a federal level. So the federal level is 12 million per person. There may be some lower thresholds for state, but for most of my clients who kind of fall within that 10, 20, 30, 50, $70 million net worth model, they get the double dip. They get great estate minimization tools, because if you're saving taxes and passing a larger legacy, isn't that a form of asset protection?
Absolutely.
Right? It's not the car accident. It's the government. You're preserving your assets, and some of these are timely. And just to kind of throw out a little coming attractions, right now the current Biden administration is trying to, especially effective 1/1/2023, they're trying to make some modifications and to accelerate some of the laws that will become effective as of 1/1/26. The current Trump laws will naturally expire January 1st of 2026. And the Biden administration is trying to accelerate that date to make it effective 1/1/23. Whether or not the current administration has enough political equity to be able to do so has yet to be determined. But we do know that we do have a clear line drawn in the sand that January 1st, 2026, we want to do stuff now to kind of capitalize on that. Because it could be one of those, one last thing, it could be one of those things that if you use it or you lose it. And if you don't take advantage of this now, you may wind up being a little disappointed in yourself later in the future.
Understood, and great. And thank you for pointing that out. And I think some of the things that affect most people is the capital gains tax, the forgiveness for the estate passing on, as far as the 12 versus $24 million, and those things potentially being changed, going away, etc., etc.
Yes.
Got it. And so, great. So basically, having expertise in this area is not something that I personally have, but I'm always impressed with people who do. So thank you for bringing that up. Let's talk about why would somebody be afraid of that? What are the kind of consequences that we are talking about? What are the assets that we would protect, and why we would protect them? And when does that in your world most commonly happens?
Okay, great question, because you actually have 3 questions tied up inside there, and those are great questions.
Sorry about that.
No, perfect. No, it's great, because these are all things that need to be addressed and need to be understood. The first one, let me talk about, you talked about a timing issue. Before we get into the needs for this, I think a very important thing to talk about is timing. If, as they say, if I had a nickel for every time that somebody asked me, I've given enough talks over the years, and I've interfaced with enough people where we talk about asset protection planning, and it just kind of like we all get busy, and life kind of goes on, and it sounds like a great idea, but you never quite implement something. But there's a timing issue that's involved here, that whenever we get involved in any kind of attempts to protect and preserve assets from the claims of creditors, you need to do it before the need arises. And I like to give a very simple example, Tom. I say, listen, if you have a car accident on Monday, all right? So Monday you had the car accident. You then start shifting all of your assets to these LLCs, these trusts, and to your kids and to Uncle Bob on Wednesday, right? Accident happened on Monday, and you start moving assets on Wednesday. Now, because the accident happened on Monday, they may not have sued you yet, but the incident that gave rise to the right to suit happened on Monday. So anything that you're doing post-incident is now going to get scrutinized by the court. And there's something called a fraudulent transfer, fraudulent conveyance. In California and other states, it's even called a voidable transaction. And so what happens is that if you wind up trying to do any kind of asset protection planning after the fact, you run a very serious risk of it being unwound, to be set aside, in other words, to be ineffective. And so timing is actually very important. And so I always like to give a very simple analogy that if you're driving home and God forbid your house is on fire, you can't then call your insurance company and say, I want to buy fire insurance, right? It's already too late. You have like a pre-existing condition. So timing is, when do people want to do this? You want to have it in place before you need it. It's no different than any other form of insurance policy. We all have auto insurances. We all have commercial liability policies, EPLIs, umbrellas, et cetera, just in case you need to use it. Asset protection planning is another form of legal risk insurance. So timing is critical. Now, with all that being said, Tom, that's not to say that just because something happened doesn't mean that you can't do any planning. You can, you just got to be very careful in how you do it. You don't want to be offensive to the court. And you also want to make sure that you don't exceed the client's expectations. And this is where working with an experienced asset protection attorney makes all the difference in the world. Because there are things that I like to call the things that you can do and versus the things that you should do. And the cans versus the shoulds is about 24 years of experience.
Fair enough.
Right? Okay. So that's kind of the timing question. And now the reasons why. It's very simple that all of us, and you even mentioned it, most of litigation, I would say a substantial majority of the world's litigation takes place here in the United States. I think that's just kind of our culture and the way that our legal system is designed. And not that that's necessarily a bad thing. It's just, it is what it is. And so all of us have assets, and we all have a different makeup of assets, whether it's residential homes, vacation properties, brokerage accounts, insurance policies, retirement assets, business interests, LLCs, corporations, limited partnership interests, general partnership. We all got this mixed bag. Mm-hmm. Well, along with those mixed bag of assets also comes the risks that we all engage in on a daily basis. Now, whether the risk is driving a car, running a business, putting a product in the stream of commerce, having an employee, having a spouse, having kids, having adult kids, having a dog. I mean, you name it, there's rental properties. I mean, the list goes on and on and on. And so now that we have kind of like your financial statement, you have your asset side and you got your liability side. So acknowledging that we have liabilities, how do we properly structure the assets to insulate them from the liabilities? So once we know what the assets are and we know what the potential liabilities are, we then start insulating them through these various asset protection tools that we have to come up with a plan. And that's what an asset protection planner does. Analyzes the scope of what you have. What are the risks? What tools do we have to use against the known or expected creditors? All right. That's really it.
I love it that you have kind of put it as a platform, as a process. It's more than just, identifying two assets and putting them in a specific protected.
Yeah, it's not a corporation. No, I got an LLC. No, listen, I like to say that there's the art of what we do, and then there's the science of what we do. The science of what we do, you know that already, Tom. It's LLCs, it's corporations, it's trusts. Okay, you know the science, but what you don't know is the art. How the finesses, the psychological components, how does it actually play out? How do you use it to strengthen your negotiating position? That's the art of what we do, right? And that's why you really want to work with an experienced planner.
Wow, and we get into science because that's something the audience would like to hear as well. But let's talk about just quickly. You're mentioning the litigation as being one of the things that we want to be protected. Another one is transfer of property, generational or otherwise, business transactions. What other types of things do we need to consider as potential sources of liability to be able to work with an attorney like yourself to protect ourselves?
Okay, well, I'll kind of wrap that into one because we kind of just addressed some of the liabilities at large, but what you just said is about succession and liabilities and what to think about. Now, this kind of answer that question, hopefully in one statement, but also kind of answering both concurrently. And something people don't think about is, well, what if you're involved in a family business and you have part of your succession planning your daughter, and you want to give your daughter 10% of the company she's been with you or more because she's been working with you for so many years and really kind of help make this thing a success, which is very common. And that's kind of my father and I in our own business. Mm-hmm. Thankfully, I've been with him, and I think the office has grown and appreciated in value and client base because of the acts of both of us. So we have a partnership arrangement. But you may love your daughter very much and have great trust in her. But what about her creditors? What about her husband, right? So now when you get into a succession area, a lot of people say, oh, well, give my daughter 10%. Let's give her 20%. And you did a gifting program as part of estate minimization. But now all of a sudden, what if your daughter has a liability? She has a car accident. She has a divorce. She has a drug or alcohol problem. She gets into a car accident, God forbid, and becomes special needs issues. What do you now, as the patriarch or matriarch of the family, who just gave away 20% of your primary asset? How do you now deal with that? Mm-hmm. So part of a succession and an estate area was, how do we deliver that in a protected format from the claims of the daughter's creditors, her future divorces, her bad judgments or whatever. So you got to build in those mechanisms. So a lot of people don't think about that. And I see a lot of just, oh, I want to give, and you could even apply that to employees. Happens all the time. Key employee, I want to give them 5%. So thank goodness the office is doing so well, blah, 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 blah. Now you got all those exact same issues, not for family, but for your key people. There is a right way to do this. Don't think about the asset protection and succession as just as a one-dimensional. You really got to think about it from multiple layers.
Understood.
Yeah.
And that is something that all of us deal with when we have kids and we put kids on a joint account. Kids' behavior may impact us to lose all the money in the account.
Absolutely. I've seen it too many times.
Absolutely. And so that is one of those things that we don't think. We think that the point of transfer is our responsibility to make sure that it happens, but we are not oftentimes thinking about what does it mean and how reliable people that we are involving in our asset management schema, how reliable they are, and what liabilities that brings about.
Right.
So that is great, and that is uncomfortable but necessary to discuss.
Yes.
So let's talk about. So we know why, we know what it is. We mentioned a few hows. So I don't want to create a persona here that we're going to be talking about. What are the most common services that you provide to the business owners or members of Vistage, for example?
Perfect. Okay, so you'll start off with just like your basic building block, right? So your basic building block, most clients they'll come to us and they'll have like a corporation, or maybe they'll have an LLC. And so then what happens is that, Tommy, you even start getting a little bit of pushback saying, well, I don't really need this because I have a corporation or I have an LLC. And they've done certain things on a business level that they haven't equally treated themselves on a personal level. So you start now breaking apart, as they say, the layers of the onion, right? So now you look at, well, what's inside that corporation? What are the corporate assets and what are the corporate liabilities? And so you start breaking those things apart. So and then you look at the same thing on the personal side. So the tools that you're alluding to are, okay, now an LLC. How do we break LLCs down to make them most useful? How do we make subsidiaries appropriate? How do we use certain types of trusts? And when I say LLC, it goes back to that what do you call the science, not the art, the science. It is the tool, but there are many different ways of forming LLCs. We are a country of 50 different states, which gives us 50 different state laws to pick and choose as to which LLC we want to hold. And I can tell you, Tom, that not all LLCs are created equally. And depending upon what you're doing, what the activities are, who the owner is, and the source of liability, we use different states. Could be Delaware, could be Nevada, could be Texas, could be South Dakota, could be Wyoming. We use different states for different reasons. And so we first explore the landscape of what the assets are, and we start compiling these LLCs into like a little bit of a wall.
Yes. Because
as I mentioned, it's about asset protection and settlement. So if you build up the wall correctly, you now have a bit of a fortress, right? You have this impenetrable wall that even though they may win the litigation, they can't get into the wall to grab the gold, to get where the real assets are. So
let's give a nugget to the audience and just tell us, for example, difference between two different states. Just essentially, that would be kind of like an expertise demonstrated, right?
Okay, good. I'll just use my home state, California, versus our sister state, Nevada, because they happen to be they're close in geography, but they're miles apart, light years apart, I guess, when it comes to asset protection. Yep. So but you have to also understand that there's a big difference as to where the creditor lies. And if you've had my father out as your Vistage speaker, you may recall through some of the diagrammings, there are things that are called internal creditors, and then there are external creditors. So you first need to know where the creditor is located. And for purposes of simplicity for the audience, if you have an activity that arises from within the business's activity. So for example, you put a product in the stream of commerce, you have an employee, someone comes on the property and slips and falls, they are internal. They're inside whatever the activity is. Okay. Tom, when it comes to that, There really is no difference. So you can be in California, you can be in Nevada. It doesn't make a difference. We really need to know where the creditor resides. Now, and I'll go to the outside, an external creditor. This is very important. So now all of a sudden, Tom, you have a business and you're driving on a Saturday to go visit your sister and you have a car accident. It has no activities, no relationship whatsoever to your business, whatever that business is. That creditor, that car accident creditor, is now external to the business, right? Internal, the rights arose from the business activities. External, unrelated. Now that is a huge difference. Now, how? Because in some states like California, if the protective characteristics of that LLC, for example, don't result in a favorable remedy, an equitable remedy in the eyes of the court, and what does that mean? Whatever the person wearing the black robe says it means, right? If that doesn't result in a favorable outcome, then the judge has the ability to foreclose on the assets, to make judge-made remedies.
So he can reach outside of the box.
That's right. Actually, they can reach inside the box, inside the box, and have what's called a judicial foreclosure. And so other states don't allow, they basically specifically say that there is no judicial foreclosures allowed. So those states basically prevent somebody from reaching in regardless of how fair or equitable it may be to the person attacking you. And from our point of view, when we're trying to protect our clients' assets, we want to give them the most protective structure possible. It's not about fairness to who's attacking. It's about being able to protect the asset. So if you decide to enter into a settlement, it's something that's favorable to you and not something that's being stolen away from you. Understood. And that's a big difference between different states. It's the integrity of that box. Can someone just reach in and grab it ad hoc? Or does the box have a lid that they simply cannot get in? And so that's a very simple example.
It's a great example.
Yeah.
And I can imagine that you have different cases in different states for different purposes.
That's exactly right. Yes.
Or different things are outlined in the bylaws of the state, and they apply for the condition that one customer, but not another customer, will benefit from.
Right. That's right.
Beautiful. Right. So we have these LLCs that essentially are kind of an entity protection, and they are limited liability, meaning that they protect an asset inside from being spilled to the outside, or outside being spilled into the inside.
Correct.
Depending on the objectives. So, and that was one of the things that I think your dad has explained, that if you have 3 trucks and each truck is an LLC in itself, chances are that if one truck makes a boo-boo, right, that truck is exposed. But if you have 3 trucks in the LLC and one makes a boo-boo, all 3 trucks are exposed.
That's exactly right. It's a matter of diversification, right? It's just diversification, isolation and insulation. Because like you said, and you're giving the truck example, I actually like to use real estate because it's more people have rental properties than they have fancy trucks. But if you have, but you're right, if you can bundle all of those properties into one LLC, and you're right. The challenge is that property 1's problem becomes property 2 and property 3's problem. Why? Because they're all inside the same box. Proper diversification, so long as it's justified for other reasons, maybe box 1, property 1, box 2, property 2, box 3, property 3. Now, same scenario. Problem in box number 1, maybe it takes down box number 1, but now it has no impact on 2 and no impact on 3. Because you've isolated and insulated, isolation and insulation, and that's part of it. But there's a metric to that, right? And that's you just don't. The takeaway shouldn't be every asset's in its own LLC. Great, I would love to have you as a client, but in reality, it's cost prohibitive. Not only maybe on inception, but even your ongoing annual maintenance fees. So you got to have a practical approach. Not to get too excited on year 1 and 2, but then you can't sustain it 3, 4, and 5 because you're getting clobbered in costs.
Understood.
Yeah.
Understood. So if you have three snowboards, you don't have to have three LLCs.
That's right. Exactly.
Even if they're Burton or I don't know, something fancier.
Yeah.
Got it. Excellent. So thank you for that. So LLC is one method.
Mhm.
Oftentimes they mention this bear of a word called trust.
Yep.
So what can you tell me about the trust? What can you tell us about the trust? When are trust appropriate? What assets categories, what situations, what circumstances, what customers?
Okay, so let's talk about one trust in particular, because Thomas, there are about
Dozens.
as many trusts as you can imagine, right? However creative you want to be, you can kind of come up with a trust for it. So let's just stick with probably the number one trust planning tool in the asset protection space, and that is a asset protection trust, or asset or wealth preservation trust.
Okay.
And they fall into two broad categories: domestic, and then you have international. You've heard of domestic asset protection trust and offshore asset protection trust. And we do both, and they both have benefits. They both have the downsides, and based upon what you need. Again, not every tool is right for every circumstance. So maybe you even have both of these, but the tool is pretty much the same regardless of its jurisdiction. And the reason why you use a trust is because all the other tools that we've already mentioned, we mentioned corporations, we've mentioned LLCs, we've even mentioned limited partnerships in passing. Those are all great, but they all have one big deficiency. And that big deficiency, Tom, is you. You are the owner of that. So if you have the LLC, and we talked about the external creditor, remember, internal, even the trusts are irrelevant. It's external. The problem with the LLC is not the LLC from an outside grab. The problem, Tom, is that you are the owner of the LLC.
Mm-hmm.
And the reason why, remember I gave you the Nevada versus California. California can reach in, but Nevada cannot reach in. Okay, so if the creditor cannot reach in, that's because they have the remedy called a charging order. Okay, charging order. That's a fancy way of saying a lien. And then now I like to give people the understand what is a lien, just as an understanding. It's like having a mortgage on your house.
Mm-hmm.
If you have a home that's worth $1 million and you have a $600,000 first with I don't know, Bank of America. If you sell the home, who gets paid first? Bank of America.
Mm-hmm.
How much? $600,000. They get paid first, and you only get paid second. They have a first perfected lien. Okay, most people understand that. So now let's take a look at our LLC and what's the deficiency. Tom, I sue you. I sue you for $1 million. You have an LLC in Nevada, great jurisdiction, and the asset is worth $1 million. So you have $1 million asset in an LLC. I have $1 million liability. I then get a charging order over your LLC. Can I get in? No, but I have a lien. So what does that mean? That means I can't get in, but Tom, just like the bank, you can't get any money out either. Because if you take money out, just like you sold your house, who gets paid first? The bank, the lien holder. How much? $1 million. So you got this great asset protection tool. Mm-hmm. Yes, they cannot get in, but you can't get money out. Now that's the deficiency. That's a problem. If you've got to pay your mortgage, you got to live, your kids' tuition, you got to pay your lawyers, you got to pay credit card bills. But guess what? All of your stuff is locked up. It becomes a waiting game. So now comes a trust. When you're a trust, what do? We divest you of the ownership of the LLC. The ownership is no longer you. You were the weak link. You own the LLC. I sued you. I got a charging order. I got what you got. But now when it comes to a trust, Tom, you don't even own the LLC. You control it, but you don't own it. So now I sue Tom. Tom doesn't own anything. So what do I grab? I can't grab the LLC. It's got the $1 million in it. That's owned by the trust. And Tom, you may be a beneficiary, or a family member may be a beneficiary. So now what you can do is you say, well, now I got a mortgage payment. I got my credit card bills. I have my lawyer's fees. I got my kids' tuition. So now what do? I can send those bills to the trustee, The trustee then pays it
without going through me.
On behalf of the beneficiary, and Tom, you, the problem, never touched the money. So here you're able to use and enjoy the money without ever touching it. Because remember, you're contaminated with creditor problems. So now you're able to use and enjoy the funds without ever touching them because you're a beneficiary of a trust. That's completely different.
Got it.
Under those circumstances, that's why people establish wealth preservation trusts. And again, what goes inside there? How much do you have a tool like that? That again, we're back to the art side of what we do, right?
Yep. It doesn't make sense to do it
Right.
for a $10,000 piece of property,
right?
But at some point, it starts making sense.
That's right.
Absolutely.
Yeah.
Now, there is one thing that I oftentimes get asked at this point, and by the way, thank you for explaining. This is the best explanation I have heard so far about the delineation between LLC trust and what are the benefits.
Great.
Thank you. This is really, really worth a lot. Is there a, for example, taxation issue, transferring assets into the trust?
Now, this is going to go back to the type of trust. So the type of trust that we just talked about is something that's called a grantor trust, Grantor. Now, a grantor trust for tax purposes does not exist. So whatever asset you put inside that trust, the tax effects, income, capital gains, deductions, that's right, flow through to your 1040. The K1s, the 1099s, the income, the expenses all flow through to you. The trust exists legally, but does not exist for tax purposes. That's the nature of that trust. Now, we also talked about other types of estate planning and wealth transfer trust. Those are different. Now, those do have a tax effect. You have completed gifts. You no longer own it. The income, the capital gain is taxed at the trust level. So the answer to that question, it's like the depends.
What you want to do?
What's the purpose of the trust, right?
Got it.
So but there typically are two different broad categories: grantor trusts that are just flow through, and non-grantor trusts that are their own taxable entity. And why we choose one over the other goes back to its intended purpose.
Love it. And I will reach out to understand more details and see how that applies to my case, which my case would not be of interest to anybody else. So, and that's an interesting part, because it is not a science that can be communicated in half an hour.
Right.
It's not an art that can be communicated in half an hour.
Right.
Are there any, some of the people that I have worked with just reminded me that they believe that their credit worthiness would be diminished if the properties were in a trust. Is that true? Or in an LLC?
Okay, so I actually have no personal knowledge of that happening. Not to say that it wouldn't, because I think it depends really on how your financial statement is presented to the underwriter for the credits, whether it's a personal line or a business line. And I can tell you that banks don't like using assets as collateral where they themselves are unable to collect on those things, because those asset protection tools work against banks too.
Got it.
So if that's an issue, and I have been in situations where banks are nervous about it, then remember, let's go back to the very, very beginning statement about what is asset protection. To protect your wealth from the claims of third-party creditors that are coming after you. Now, we call this, and my dad likes to use the word blindsided. These are creditors that we did not voluntarily bring into our life. These are like unknown whatevers, car accidents, employees, product problems. That's really what our target audience is. Now, when you're getting a loan with a bank, for whatever reason, now you are voluntarily bringing somebody into your life, and you are collateralizing your assets. So sometimes what we may have to do is basically crack the cookie jar a little bit to let the bank see what's inside, maybe even let them have a key to the back door, because otherwise they will not let you get the loan. So I'm not saying that it affects creditworthiness. No, I think what it deals with more is banks are looking to secure their loans with collateral, and we may have to open up a little bit to let the bank in, because as a voluntary creditor, right?
Absolutely.
So that they can underwrite the loan and yet still feel protected against the structure at large.
Which is fair, and that is the objective of
totally
the creditor.
Totally fair.
You know, and so it is, and our objective is not to, you know, disable our creditors from collecting.
Right.
It is to make sure that we do not have an inability to be creditworthy anymore.
That's
in other
right.
words, that can be worked, and essentially that is where the continuous relationship with your attorney is necessary, or could be necessary.
Yeah.
Though I have heard also cases that in many cases banks simply don't care.
Yeah, well, yeah, that's also the case too. But most times it depends on who the bank is, right? Because if you have a sophisticated bank, a business bank, for example, then fine. Typically they get it. But if you have your typical everyday consumer bank, you may have to go up the chain of command a little bit to get to someone that actually understands what you're trying to do.
Got it. So this, of course, I can burn the rest of your afternoon, and that's not the objective. So let's try to bring this thing to a close. Is there a criteria that would be a call to action, in a sense, for a person worth some amount, having certain liabilities? What would you say is the most common profile of a customer that reaches to you regarding their business situation, value, their wealth? What would you say?
All right, here again, it's Tom. You're asking great questions, and this is just another one of those.
It depends.
No, I don't even want to say it depends, because I don't think that there actually is I think there are some clients that are it makes more sense cost wise, but everybody has a different risk profile, and it's not really asset driven, but to some extent it is asset driven, but sometimes it's just risk profile driven. And I have many clients that have relatively modest assets, a house and a bank account, right? But they're engaged in blasting business. Right?
Got it.
There's no safe way to do blasting, right? So their risk profile is so high that now it cost justifies the need to do something that if you were a school teacher, we wouldn't do, right? So it's not just your asset profile. You got to take into consideration your liability, your risk profile, right?
Love it.
And then again, it's all about balance, right? You don't have to hit a gnat with a sledgehammer. You just got to have the right tool. If you can get away with a house of sticks, no need to invest in a house of bricks, but you may need to invest in something, right? So I would say that almost anybody, literally almost anybody with some assets, a family, a house, needs some type of protection. You know, and I'll leave it at that, right? Because I think that I don't want to be inclusive or exclusive, right, of anybody.
Absolutely. And I mean, there is also this aspect that is very individuals, which is the risk tolerance.
Yeah,
right?
Oh yeah, for sure. Or risk and complication tolerance, right?
Absolutely,
yeah.
Absolutely.
But I'll tell you, but there's been many times where I've gone to people and said, I'm very thankful that you reached out to me, but you know what? You're just not my client, right? I can't do anything for you, right? So, like I said, I'll leave it at that.
For those that would like to reach out, and for those who believe that they should learn more, if not engage, how do they reach out and how do they connect with you?
Right. So the best way is just through email, you know, kind of like we all live by our email. It's on our phones, et cetera, et cetera. So it's just my name, Brad, B-R-A-D, and at my last name, at Barth, same last name, B as in boy, A-R-T-H, attorneys, ATTORNEYS.com. So Brad at barthattorneys.com is the best way to kind of people they make the initial reach out. We do have I have electronic calendaring. We actually have some, maybe one of my partners may get in contact to make first contact to get you on the calendar. So that's the best way, literally, is just to kind of just reach out and shoot me an email. Heard you on a Vistage talk. I want to have an exploratory conversation. Can we set up some time? And I'll promise you, I'll get you on calendar.
Love it. As I'm listening to you, one thing we didn't mention, wills.
Yep.
Is that part of the trust as well?
Yep. Yeah. So normally when we talk about a trust, it's just one part of it. But what you're referring to is a more of a comprehensive estate plan.
Yes.
And that comprises of powers of attorney for healthcare, for financial management. Then you have wills and you have trusts. Now that's not, don't confuse that trust with some of the asset protection trust. They're very different tools. But yeah, when we say trust, typically we're referring to as an estate plan, and a will would be a part of that.
Yes, absolutely. I love talking to specialists, to people with a great deal of expertise, because it turns out that there is no simple answers. Why? Because the body of knowledge is so huge,
right,
that frankly things that may look simple to me, they look simple to me because I'm coming from a state of ignorance. So thank you for opening my eyes today. Brad, this was excellent. I will leave your contact information in the points and notes of the meeting. And I look forward to personally reaching out to you and chatting more. Any closing words of wisdom to my Vistage audience?
Yeah, I think it's always a nice little takeaway is that I think, and this is my personal opinion, that there are 5 components to what most people would deem a financial plan. If you're working with a financial advisor, you got your insurances, you got taxes, investment planning, income tax planning, and estate planning. Those are like your 5 key areas of any type of financial planning.
Mm-hmm.
And what they're doing is you're trying to get your investment portfolio from 4% to 7%, or we're trying to save you 2 or 3% on your taxes by giving you this type of investment class. But you're talking about single-digit changes. And so what I believe, and I think an important message to leave your audience with, is that there's a missing 6th element to a comprehensive financial plan, and that is asset protection planning. Because you can have all these things in place,
mm-hmm.
but if you get into a lawsuit, you can lose not 20%, not 40%, not even 80%, but up to 100%, where bankruptcy is the result. So it's not about saving the 3 or 4% on taxes or getting your portfolio to do 2 or 3% better. You need to make sure that you have at least some type of insulation from those unknown events. So I think a good takeaway is consider asset protection planning your 6th element of your comprehensive financial plan.
Love it.
Yeah.
Love it. And play by the rules that are known up to 2026.
That's right.
Yep, I know. I hate deadlines like that, but that's the reality, and we better be in agreement with the reality. So, Brad, thank you so much for today.
Right.
This was a joy for me to talk to you, and thank you, and say hello to your dad.
Right.
Looking forward to connecting.
Right. Thank you. Right, Thomas. Thank you. All the best. Bye. Bye. Bye.